Today's session is all about the key data protection considerations for Harbour Authorities. So we'll get started by introducing myself and Zoe. So I'm joined by Zoe today, and Zoe is an associate in our risk and regulation team. And I think a number of you will probably already know Zoe because of the prosecution work that she does with a number of the Harbour Authorities that we work with. So I am then an associate in our data protection team. And so regularly advise our Harbour Authority clients on data protection issues that arise from time to time. So I've got our agenda for the session on the slide here, which we'll walk you through. And actually, just as we've had a few more people joining, I'll just sort of go over that housekeeping again. So we are recording the session just for everybody's awareness. And so if you're able to keep yourselves on mute and with cameras off, and then we'll do Q&A at the end. So the agenda for today's session is on the slide for you all here. So we'll start by having a look at the law and what the law says. We've got two different regimes that are relevant. So that is the law enforcement regime under the Data Protection Act. And then we've also got the UK General Data Protection Regulation regime. And we'll look at when each of those regimes apply. We'll look at the documentation that you need. We'll then hand over to Zoe, who's going to talk you through some criminal investigation considerations. I'll then have a look at some data sharing scenarios. This will be when it's lawful to share personal data with third parties and what you need to think about when requesting personal data from third parties. We'll then have a little look at some video surveillance considerations, and then we'll end on some practical takeaways for you. So first up then, a quick summary on the law. Now, the reason I want to start with this is because, as I mentioned, we've got two different regimes at play. So we've got the law enforcement regime under the Data Protection Act, and that applies when a competent authority processes personal data for law enforcement purposes. And Zoe's going to look at this in a bit more detail when she comes onto criminal investigations. But a competent authority is a body that has statutory functions to exercise public authority or public powers for law enforcement purposes. And so Harbour Authorities will be considered a competent authority. And when Harbour Authorities are processing personal data for the primary purpose of law enforcement, this law enforcement regime under the Data Protection Act is going to apply. Now, this is an entirely different regime to the UK General Data Protection regime, and that's abbreviated to the GDPR. And the UK GDPR doesn't apply to law enforcement processing by competent authorities. But the UK GDPR regime is going to be relevant to you all because it will apply to any processing of personal data by a competent authority, which is not for the purpose of law enforcement. So some of the key examples that would be relevant to you all would be your HR data processing, so any processing of employee personal data.
Sorry to stop you there, Hannah. There's just been a message that someone can't hear you. Could you just put and raise your hand if you can hear Hannah, just to check?
Oh, perfect. I'm glad.
Brilliant. Sorry. Thank you.
Thank you very much, Zoe. So carrying on then on those examples of data processing that would be caught by the UK GDPR regime. So we've got if you're holding vessel owner details in respect of harbour dues and licensing of vessels, perhaps if you're collecting survey results or feedback from people's experiences of engaging with the authority, or if you're promoting or marketing new facilities or offerings, all of those things that aren't law enforcement processing would fall under that UK GDPR regime instead. So throughout the webinar, we'll signpost you when we're talking about each regime. And what I wanted to cover next before we delve into any of the particular topics in detail is just a quick summary of the documentation that we would expect any organisation to have, but specifically Harbour Authorities, to ensure that they're complying with data protection law. So you can almost treat this as a bit of a checklist and think, do we have these bits in place? Is there anything that's missing? So data protection impact assessments, and that's something you'll hear us talk about throughout the session. And effectively, this is a risk assessment for higher risk data processing activities. So what you do is you assess the risks and you document what mitigations you're going to put in place to address those risks. You've then got your privacy notices, and these will primarily fall into two categories. So you'll have your internal privacy notice, which is for your employees, and this tells your employees how you're going to process personal data about them. Often you'll find this in your employee handbook, or it might be provided to employees alongside that handbook. You'll then have an external privacy notice, and this is the privacy notice that's most often made available on your website. And this tells people like customers or members of the public how you're going to process their personal data. And then the final category is your suite of internal policy documents. So the key overarching policy is your data protection policy, which sets out rules for your personnel when they're processing personal data for you. And it will cover both your law enforcement processing under the law enforcement regime, but also your data processing under the UK GDPR. And what you'd probably end up having is a separate section which is tailored to that law enforcement processing. We then expect you to have an appropriate policy document which addresses sensitive categories of personal data and how you're going to protect those. And examples of those sensitive categories are things like racial and ethnic origin data or health information. We'd then expect you to have a CCTV policy and also a retention policy or retention schedule. Now I'm going to hand over to Zoe, who's going to look at criminal investigation data processing. And this is where that law enforcement regime that we touched upon at the start will apply.
Thank you, Hannah. So Hannah's talked you through kind of the law which applies in respect of data protection. So what does this mean in the context of criminal enforcement? So data protection in the criminal context is covered by the law enforcement regime. So this is part 3 of the Data Protection Act. Now, as Hannah mentioned, you're a Harbour Authority and therefore you are a competent authority because you have statutory functions for law enforcement purposes. Now, when an incident occurs and you start collecting information about an individual, whether this be for the prevention, investigation, detection or prosecution of a criminal offence, and this includes safeguarding against and the prevention of threats to public security, you are collecting data for law enforcement purposes. So this means when, for example, you take a photo of an individual speeding within a harbour, you are acting as a competent authority for law enforcement purposes and you need to comply with Part 3 of the Data Protection Act. So personal data will cover things such as the videos and the photographs you might take on your phone, when you take down notes of an individual's name and address, or even when you quickly message other harbour officers a description of an individual and their vessel. Now, an ICO has recently reprimanded a harbour authority for their failure to comply with the enforcement regime. So it is something that they are very alive to, and it's something that you need to be alive to as well. Slide, please. So complying with the law enforcement regime essentially means complying with these 6 principles. So this means that whenever you collect or process data within the criminal or context, that processing must be lawful and fair. The purpose of it must be specified, explicit and legitimate. It must be adequate, relevant and not excessive. Personal data must be kept up to date and accurate. It must not be kept any longer than necessary, and it must be processed in a secure manner. So when you're on a water, the most likely place that you will be processing data is through your phone, whether this be a work phone or a personal phone. You might use it to take photos and videos or message other harbour officers about details of an incident and any individuals involved. And you might also be scribbling down information in a notebook, such as somebody's name and contact details. Now, I appreciate you also might be recording data through a body cam, but this is something that Hannah's going to cover next. Now, as a quick side note, everything that you write down, whether this is via text, WhatsApp, or email that concerns that individual, has the potential to be disclosable to that individual under a subject access request. So the golden rule is, before you write down anything, pause, think, how would this sound if you listen to this being read out in a court of law? And 9 times out of 10, you'll probably tone down what you're about to write. Now, mishandling of personal data can not only breach data protection laws, but it also risks undermining the credibility of evidence. And poor security measures can lead to risks and accusations of tampering or manipulation of data. Now, even if these allegations are untrue, defence of them can be very costly. So it's really important that you have robust security measures in place in the first place. I completely appreciate things move very rapidly, and you're often thought of quickly when gathering information and how you're going to record and communicate this to others within the harbour. The last thing you are thinking about when you're doing this is, am I compliant with the Data Protection Act? So what can you be doing now to ensure that when those incidents occurs, you are automatically going to be compliant with the above principles? Slide, please. So number one, risk assessment, and you will hear me say this a lot. Now, the ICO has recently confirmed that whilst it is not unlawful to use private messaging apps, such as, for example, WhatsApp, to conduct official business, all organisations need to consider the risks to personal information when using these apps for business purposes. So practically go away, write down what those 6 principles are and do a risk assessment against them, looking at the ways you gather data. And this also ties into a data protection impact assessment you need to be carried out. So consider the risks around the personal information and how you're going to mitigate those risks. If you are planning on setting up a WhatsApp group to share information on criminal matters, whether this be on Teams or WhatsApp, have a think, who's going to be in that group? Who should be the administrator? And what are you going to be using that group for? You will then be able to know what are the risks to protecting that data and how can you mitigate them. Now, the most obvious risk is breach of the principle that the data is not processed in a secure manner. So what can you be doing to improve security? Consider, for example, is it appropriate to issue work devices in order to manage the security measures in place on them? Or if it is necessary for staff to use their personal devices, make sure that you issue really clear rules on how they can be used. So next up on the screen, we've got policies. Now, again, I'm going to return to this recent case from the ICO as they reprimanded a harbour authority for not having appropriate policies. And they said that harbours need to review all organisational policies and procedures relevant to new apps and amend where appropriate. So policy examples might be things such as your law enforcement policy. Make sure that you don't just have a policy on data protection, but it's very, very specific to data protection in the context of law enforcement. Similarly, a retention policy, this needs to set really clear timelines for your data retention, ensuring that data is not retained any longer than is necessary for the law enforcement purposes. Now, this might be having really simple messages, such as having that downtime at the end of the day to review what data you hold, whether any of it needs to be deleted, and whether any needs to be transferred to a secure site. Now, Hannah briefly touched on appropriate policy documents. So this is required whenever sensitive personal data is processed for law enforcement purposes. So this includes processing data about an individual's race, their ethnicity, their political views, their religious beliefs. Now, it might not always be immediately obvious that you are processing sensitive data, but the most obvious one is when you're describing somebody, you might be giving a description of their racial information. Similarly, if you're reporting a medical incident, you might be reporting information about that individual's health. Now, just to give you reassurance, if you process criminal offence data for a number of different purposes, as you probably do, you don't need a separate policy for each condition or processing activity. You can have one document to cover them all. Also should flag that I completely appreciate a lot of harbour authorities do work with the police. And if you do, for example, have a WhatsApp group where you share information with the Marine Police, just make sure that you do have a policy which covers both sides of those people and make sure that you are protecting data transferring between you. So communication and training. There is no point to having good policies if your personnel do not know about them. So make sure that they receive very explicit communications, instructions and guidance on their data protection responsibilities. And the ICO has made clear that this needs to be specific to law enforcement regime. It cannot just be general guidance on data protection. Now, training also includes making sure that staff know how to identify and report and respond to data breaches or misuse accidents should they occur. So oversight, if you are going to have one of those WhatsApp groups, then make sure that there is sufficient oversight. And again, this is something that the ICO picked up and reprimanded a Harbour Authority for. So make sure you appoint an administrator who is really clear about their role and responsibility within that group, whether it is, for example, managing what data needs to be deleted or transferred to another secure device. Make sure that control is restricted to authorised personnel, and make sure, and really importantly, you've got in place a process for removing those members of the group if they leave the law enforcement role. Often these WhatsApp groups can have sometimes hundreds of people, and there needs to be a really good process for monitoring who is in that group. Terms of reference, really simple, really straightforward. If you're going to have a criminal enforcement group, just write something really simple which defines what that group is to be used for. Now, internal reviews, monitor your compliance. Now, this does not need to be a long or complex or costly process. It can be really simple as having a nominated individual once a week doing a quick review of any WhatsApp group to see if there are any photographs or videos which need to be deleted, and make sure that they remedy any non-compliance and learn from it. Equally, it might be something really simple as having another nominated individual having a whip round of the office every day, just seeing, are there any notebooks which have been left out on desks, which have scribbled down, for example, somebody's name, address, contact details, and just making sure that those notebooks are put away in a locked drawer. Now, mobile phones are incredibly useful devices, and I certainly do not want you to discourage you from using them. But you do need to make sure that if you are going to use them, that the risks of using them are appropriately mapped out and mitigated against. And you need to have really strict policies and guidelines, and even stricter ones if individuals are going to use their personal phones. You also, in your privacy notices, need to make it really clear to individuals that you might be processing their data on social media apps, so you have that level of transparency. So you've collected the data, it's been processed. I'm now going to hand you back to Hannah, who's going to talk you through what you need to do if you're asked to share this data, or equally, if you want to request data from a third party.
Thank you, Zoe. So, like Zoe said, we'll have a little look now at some data sharing scenarios. So what I wanted to do is walk you through a couple of specific examples to sort of illustrate where the data sharing sort of challenges are and what you need to be thinking about. So I'll start by saying if you receive a request for personal data from a third party, and that third party has expressed statutory powers to request that information from you, you'll need to provide that information to them. Oh, I've just seen that we've got a hand up there. Was that a question or just a concern about the able to hear us or anything? If it's a Q&A, we'll deal with those at the end. So I'll just sort of carry on with the content for now. So yes, if you receive a request from a third party and that third party has expressed statutory powers to request that information from you, you will need to provide that information to them. So that will be the starting point. However, you can ask them to explain what that power is. So you don't have to just sort of take it at face value. You can push them and ask them to justify what that power is so that you're comfortable that you are able to share that information with them. What I'll now cover, though, are steps to take in a data sharing scenario where actually the third party that's requesting the information isn't relying on an express statutory power to require you to provide that personal data to them. So it's where you've got a bit of discretion and you're deciding, is it appropriate in the context for us to provide this data? So the first scenario I'll look at is you receive a request for vessel owner details from the Maritime and Coast Guard Agency, the MCA. Now the starting point here is the MCA is a law enforcement agency. So data protection law doesn't force you to disclose personal data in response to a request from law enforcement agencies, but it does allow you to give personal data to them on a voluntary basis, provided that you're comfortable that it's necessary and proportionate to do so. So the first question that you want to be asking in this scenario where you've been requested to provide personal data is actually, is it necessary and proportionate to share it? Now, once you're satisfied that it is necessary and proportionate, you'll then want to have a little look at whether there's a lawful basis. So there's various lawful bases that you could rely on. So these can include performance of a contract or consent, but the key lawful basis that I think is going to be the most useful one in this scenario is legitimate interests. And this is because you may consider that there is a legitimate interest in disclosing the requested information for the purpose of a fair and reasonable investigation. And that fair and reasonable investigation would then be your legitimate interest. Now, with the legitimate interest lawful basis, you have to carry out a balancing test. So what you do is you, on one hand, look at your legitimate interest, and then on the other hand, you look at the privacy rights of the individual involved, and you weigh those up. So you decide, actually, are we comfortable that pursuing our legitimate interest doesn't override the privacy rights of this individual? And provided you carry out that balancing exercise and you satisfy yourselves that there isn't, you aren't overriding their privacy rights, then you're able to rely on that lawful basis, and that then justifies that sharing. So here we would be proceeding with that sharing if we were comfortable that that legitimate interest of pursuing a fair and reasonable investigation doesn't override their privacy rights. Now, another one just to think about, and I just want to pop it on your radar, I don't want to go into too much detail, but actually you want to think about what data is being requested. Because if the MCA is asking you for maybe more sensitive categories of data, and these are some of the bits that Zoe touched upon earlier, but it's things like ethnicity information, racial origin information, health information, anything of that variety, which it's treated as sensitive data because it's more likely to cause harm to individuals if it fell into the wrong hands. Those categories of data, you need to not only identify a lawful basis to share them, but you also need to have an additional special category processing condition. And so just think in that scenario, actually, is the data that we're being asked to share of that more sensitive variety? If it is, there's a few more sort of hoops to jump through. I won't go into what those additional processing conditions are today, but just something to be thinking about. Now, if you're telling an individual that their data has been shared or going to be shared with the MCA, that's the next thing to be thinking about. So transparency. So is this individual going to expect their data to be shared with the MCA in these scenarios? Have you told them that you're going to? And the clear place that you're going to communicate this to them is in your privacy notices. So you're likely to have a privacy notice on your website, which is addressed to the general public. And that should be really clear that actually you will be sharing information with law enforcement agencies when those agencies request it for their own law enforcement purposes. And actually, in some scenarios, you might decide that that general privacy notice, say on your website, isn't enough. And you need to give a specific notice to the individual concerned to tell them that actually you are sharing their details with the MCA. And that is because data subjects under data protection law have a right to be informed about what's happening with their personal data. So they have a right to know who's processing it, who's sharing it, and where it's going. Now, the one sort of caveat to this is actually if you're telling an individual that you have passed their information over to the MCA and actually doing that could tip them off and prejudice a criminal investigation, then you would be exempt from providing them with that privacy notice information because the priority there is obviously not prejudicing that criminal investigation. Now, just an extra sort of thought on that example is if you were to receive a similar request from the MAIB, so the Marine Accident Investigation Branch, that same process that we've just walked through would apply. But the main difference is the MCA is a law enforcement agency, whereas the MAIB isn't. But it's foreseeable that actually you could have requests from both of those entities in relation to the same incident. So you want to follow that same process. So before sharing any information with the MAIB, you'd want to ensure that data sharing is necessary, make sure that it's proportionate. So you want to make sure that you're not sharing any more information than is necessary for the purpose. And you also want to make sure that you've got a lawful basis. And then finally, ensuring you've complied with your transparency obligations. So applying those sort of key 3 steps then to another very similar scenario, but actually one that we were thinking would probably crop up for you guys sort of reasonably regularly. And that would be if you were to receive a request from an insurance company for vessel owner details, potentially in relation to a crash between 2 vessels. So the first question you'd want to be asking in this situation is it necessary and proportionate? And it's likely that yes, you'll be able to satisfy yourself that it is, because it's necessary and proportionate for the proper pursuit of that insurance claim. Now, looking at your lawful basis, and again here, legitimate interest is going to be a really helpful one. And here you'll be able to point to the pursuit of that insurance claim as the legitimate interest. And that balancing test that I mentioned, where you weigh up your legitimate interest against the privacy rights of the individual, an important factor when you're doing that balancing test is actually the reasonable expectations of the individual. So would they expect you to be sharing their information in that way? And I think it would be within the reasonable expectations of a vessel owner that actually if a harbour authority does have their information and was asked for it by an insurance company, that they may well share that. So that all points towards the fact that actually it is lawful to share their information in those circumstances. And again, then transparency. And this is why it's really important to make sure that your privacy notices, so the documents potentially available on your website, are nice and clear that insurance companies are one of the categories of third party that you may share personal data with if requested. And what you'll want to do is just document that paper trail. So document that assessment. Why do you consider that that sharing is necessary and proportionate? And why do you consider that you've got a lawful basis? Just in case anybody quibbles whether or not you are sort of justified in sharing that data. Now, third and final scenario for the data sharing. And now I want to look at a scenario where you as the Harbour Authority are requesting personal data from a third party. So for example, you may need the details of a vessel owner from a third party marina. Now, the key thing to remember, and it's what we touched upon at the start, is that the UK GDPR doesn't prevent sharing of personal data with law enforcement agencies. So what you can explain to the third party marina is that actually there's nothing to stop them sharing this data with you under data protection law. But what they do need to be comfortable with is that it's necessary and proportionate to share that data with you. So when you're reaching out and communicating with them, you should be presenting the communication in a way which explains to them why it's necessary and proportionate to provide that data and why you consider that they'll have a lawful basis for doing that. Because that almost then answers the questions that that'll be sort of the logical follow-on questions for them when they seek legal advice or speak to somebody internally about whether they're able to share the information with you. And by providing them with that information up front, you're going to speed up the process of them providing you with that data. And actually, there's going to be real value in addressing some of these key relationships early on. So actually, if there's particular parties, so maybe third-party marinas, where you envisage that you will actually need personal data from them from time to time, then there's no harm in reaching out to them ahead of time so that they're really clear about when it's appropriate to share personal data with you. And when you need them to do that quickly, they're already comfortable with what they will and won't share. So definitely all about having those early conversations. Now for the next substantive section, and this is actually the final substantive section, we just wanted to have a little look at video surveillance. And this is because we know that video surveillance is going to be relevant to so many of you because a lot of you are going to have CCTV, body-worn cameras, and so it's important to make sure that the way you're using video surveillance is compliant. So what we've got on the slide here is almost a checklist of requirements for when you're using video surveillance. And I'm just going to quickly run through them one by one. So first of all, make sure that you've registered with the ICO. And the reason I say that is because if you're using any CCTV or video surveillance, that automatically qualifies you as an entity that's required to register with the ICO and is required to pay the annual data protection fee. And it's a fairly nominal fee, and it's an annual fee that you pay. You're then on the ICO register and you've ticked that box. Next then is data protection impact assessments. There's something both Zoe and I have touched upon already because they are so important, and that's your risk assessment. Now, video surveillance is ultimately invasive, and data protection impact assessments are legally required for any data processing which is likely to result in a high risk to individuals. And therefore, a data protection impact assessment is legally required for video surveillance. So you must have one of these risk assessments in place. And it enables you to assess the risks of the particular surveillance and mitigate those. Now, one of the things that's likely to crop up in that risk assessment is where are you placing the cameras? So you need to ensure that any camera locations are necessary and appropriate. And you want to make sure that you've got unobstructed views, and that means that footage that you obtain from the cameras is accurate. What you ideally want to do as well is to avoid covering any private property. And actually, if that's not possible and there are private property areas that would sort of incidentally feature in the footage, what you'll need to do is obscure those areas, and you can have sort of obscuring techniques on the camera itself, so you're actually never capturing footage from that area. So signage then, and that's just publicly visible signs. It is what it says on the tin, making sure people are aware that surveillance is happening, who's responsible for it, and that could be a sign on a wall near a CCTV camera or signage on a person that's wearing a body-worn camera. So privacy notices, they're those internal employee privacy notices and your external website privacy notice, just updating those and making sure that they're clear with people that you will use CCTV. And then that internal CCTV policy, which we touched upon at the start as well. This is actually a really key document for anyone using CCTV or any form of video surveillance, because it's a policy which sets out the rules and procedures for anyone within your organisation that's using CCTV. And actually, if the ICO were to look into your use of video surveillance, this is probably one of the key documents they would look for. And they'd want to see that personnel were made aware of the policy and they understood what their obligations were under it. Now, going hand in hand with that is training for personnel on their obligations regarding CCTV. And then final 2 points there are retention and security. So retention, I would say that retention of CCTV footage, market standard is probably about 30 days, can anywhere sort of 28 days, 30 days a month. But what we'd want to see is that that footage is being automatically purged at the end of that retention period. Now, what you can do is where there's an incident or investigation which is relevant to a bit of footage, you want to retain that as evidence. You can extract that, store it somewhere securely, and that doesn't need to be deleted at that 30-day point. But what you must do is when it's no longer needed for proceedings or the investigation, make sure it's deleted. And then all very self-explanatory, but obviously any CCTV footage must be retained securely. So think about password protection, limiting access to people that need it in relation to their job role, but nobody else, and making sure that it's stored in secure areas. So that is a very much a whistle-stop tour on video surveillance and how to use it compliantly. I will then hand over to Zoe, who will conclude things for us with just some practical takeaways that we can all be thinking about.
Thank you, Hannah. Now, before I begin, I'm very mindful that some of you have joined halfway through. So just to let you know that we will be recording this, it is recorded, and we will be sending out a copy afterwards if you want to rewatch it in full. So practical takeaways. What should you be doing now when you go away from here? So the first thing you need to do is we're returning to my favourite risk assessment. Go away, map out how, when and where you collect data, particularly within that criminal context, and identify any potential risks of breaching data protection or GDPR. Now, this includes your data protection impact assessments. The reality is you cannot mitigate those risks and you cannot have in place appropriate policies if you do not know where your risks lie. Secondly, training. Make sure you provide comprehensive and tailored training to staff on data protection, which is specific to criminal enforcement. And this is something which the ICO has really picked up and is looking at. And this includes, as we mentioned before, training on what to do if you identify a breach. The policies, we've kept on referring them throughout what these might look like. Make sure you have in place appropriate policies for what you carry out and make sure that you constantly review them. If the ICO does come knocking and you can show them that you have in place appropriate and up-to-date policies, then you are in a far better position to defend yourself. Do you, for example, have an up-to-date policy on retention? Make sure that you have appropriate signage. That means ensuring that individuals are properly informed about the collection and their processing of personal data. So this is things such as those signage of those CCTVs, making sure that you have those privacy notices. Secure data systems. Now, not having adequate security is probably the easiest principle to breach in respect of Part 3 of the Data Protection Act. So make sure that you invest in really secure data storage systems and implement encryption and access controls across the organisation. This includes what Hannah was talking about, simple measures such as if you've got CCTV, password protect it, make sure it's restricted to only authorised personnel. This also includes things such as if you have a notebook, have a drawer which is locked at the end of the day, which you can put these in. So conduct internal reviews and audits. So make sure that you have regular internal investigations which monitor compliance with the principles and the Law Enforcement Act and GDPR, and make sure that you can then remedy any non-compliance. Now, this doesn't need to be costly. As we've mentioned before, this can be as simple as having one person in charge of reviewing a WhatsApp group, seeing what photographs and videos are in there, perhaps weekly, and seeing if any need to be deleted because they've been retained too long, or seeing if any need to be transferred to a secure data system. Now, I'm really conscious of time, so if you don't get the chance to ask a question, although I appreciate we've had 2 in the box already, then please do write in. We'll have our contact details on a couple of slides in, and we will make sure that we answer it to you. Before I go on, I want to give you a quick reminder of our marine networking event in London on the 26th of November at our Ashford's office. So this will be looking at coastal development and giving a ports and harbours legal update. Looking forward, we haven't got a date yet, but we're also going to be doing a webinar which looks into modern slavery within the port and harbour context, as I appreciate this is becoming very topical at the moment.